Hello, everyone, and thank you for joining us this morning. My name is Jason Cogdell, and I, along with Chris McCauley, are benefits attorneys with ProBenefits, and we thank you for joining us this morning for our webinar on the basics of COBRA compliance, what employers need to know. For those who may be joining us for the first time, on behalf of our team, we present compliance webinars on a monthly basis, and our goal with these webinars is to assist the employers and plan advisors that work with us and help elevate the level of compliance across the board, particularly in these key areas that employers need to know about. We focus on areas that are within our realm of service and expertise, but we also seek to present topics that we know are of importance and need for employers. So wherever you may be today and whatever your relationship with us, thank you for joining us. This is the first live webinar of 2017. We tried something new in January, and we recorded a short webinar that was distributed directly, so it was not hosted live, and it was a 5-minute webinar, Plan Document Basics, What You Need to Know in 5 minutes. So if you have not seen that webinar, if you did not receive a copy of our compliance update, which was distributed on January the 20th, you're welcome to let Chris know, and he will share a copy of that session with you. This session, our goal is to provide a refresher on COBRA basics and to answer some commonly asked questions about this very significant area of employee benefits, COBRA compliance for group health plans. Chris is going to present, go through COBRA basics, a refresher, cover some commonly asked questions, and we're going to answer your questions. So your questions are welcome. You may submit them through the question box during the session. We'll also have a short time of Q&A after the session and after the oral presentation ends. But without further ado, Chris.
Thanks, Jason, and again, welcome to everyone. The COBRA rules and regulations are extensive, they're complex, and even a moderate proficiency in the rules would require a course of several days. So what we're trying to do here today is just scratch the surface, talk about the very basics, so that everyone can walk away with at least some level of knowledge in terms of what the basics are that employers need to know, and then also talk about a couple of common scenarios. There are many common scenarios and questions that come up, but a couple of the most common that we get, we wanted to talk about those just to provide some more information to you. So to start off, we wanted to just show you what COBRA is in its most simplest form, and that's these elements right here, most of which we will get into in the next couple of slides. COBRA is a qualified beneficiary who loses group health plan coverage due to a qualifying event. So that particular individual may elect to continue coverage for a limited time by paying for that coverage. And so in its simplest form, this is COBRA. One of the elements here we don't get into in the further slides is the last one, by paying for that coverage. So I just wanted to mention the COBRA premium here briefly. In order to get continuation coverage of COBRA, the beneficiary, the former active covered individual, is required to pay for that coverage, or can be required by the employer to pay for that coverage by paying a premium. Even if the individual did not have to pay the premium when they were covered as an active employee or non-COBRA coverage, in order to get COBRA or continue coverage, the employee, the qualified beneficiary, can be required to pay for that coverage by a premium, by paying a premium. And that premium is generally the cost of coverage to the plan, so the cost of providing that coverage. For a fully insured plan, that's pretty much just the premium that was being paid when the COBRA beneficiary was an active participant. So I just wanted to touch on that element here because we don't get into it in the further slides like we do some of the other ones. And one additional point before moving on, not everyone is eligible for COBRA even if there's a qualifying event. There must be first a triggering event or a qualifying event and a loss of coverage as a result of that qualifying event. So both of those elements need to be present in order to be eligible for COBRA, and we'll touch on that briefly in an upcoming slide. So again, COBRA in its simplest form. The next part of the basics I want to talk about is who is subject to COBRA, what employers and what individuals. In terms of employers, the COBRA rules apply to all employers with 20 or more employees measured on a typical day during the preceding calendar year. So if you're hovering around that 20 employee threshold, what you need to do is look at the prior year. So for example, you look at 2016, count your employees on an average business day in 2016 in order to determine whether COBRA applies to you in 2017. So if you had 20 or more employees on an average business day in 2016, then you are subject to COBRA in 2017. So that's the small employer exception. The only other real exceptions are for certain governmental and certain church plans may not be subject to COBRA. Small employers, and we're going to touch on this in one of the later slides, small employers are exempt from COBRA, but they still could be subject to state continuation rules depending on the rules in their particular state. So those are the employers to whom the COBRA rules apply. In terms of individuals, on the previous slide we talked about qualified beneficiaries. So a qualified beneficiary is essentially anyone who was covered under the group health plan prior to the loss of coverage and qualifying event. So all qualified beneficiaries must be offered COBRA, and that includes employees, spouses, and any covered dependents. So COBRA doesn't just apply to the employees losing coverage, but also spouses and dependents have their own independent right to elect COBRA if they lose coverage as a result of the qualifying events. So for what plans does COBRA apply? COBRA applies to all group health plans sponsored by employers. And the most common are the major medical plan, whether fully insured or self-insured, vision, dental plans, those are also group health plans, some cancer policies, prescription drug plans, health FSAs and HRAs are certainly group health plans, and any other plans sponsored by the employers that provide medical benefits. There are some additional plans which sometimes there's some confusion as to whether COBRA applies. Potentially COBRA also applies to employee assistance programs, EAPs, wellness programs, and on-site clinics depending on what benefits they provide and more specifically whether they provide medical benefits to employees. In addition, telemedicine is often subject to COBRA as well because it is considered a group health plan because it provides medical benefits to employees. So these are just an example of the types of plans that are considered group health plans. COBRA does not apply to the following plans: disability plans, HSA bank accounts, long-term care plans, life and AD&D plans, indemnity plans, and other individual supplemental products that are considered voluntary, not sponsored by the employer. So just in terms of indemnity plans, that's oftentimes certain cancer policies, certain critical illness policies can escape the COBRA rules because they are indemnity plans, fixed indemnity plans. And so if you have a cancer policy or a critical illness policy or a specific disease policy, you might want to look at specifically how that plan is set up to determine whether it's a group health plan or whether it's an indemnity plan that isn't subject to COBRA. So those first two slides were the who and the what. I wanted to touch briefly in terms of the when, the timeline, and this is a very basic timeline. There are other certain events that could happen within this timeline to affect COBRA, but in its most basic form, the COBRA timeline looks like this. Someone, an active employee, is enrolled in group health coverage, and they are provided an initial general notice within 90 days after they are covered. That general notice simply provides them with COBRA background information regarding their rights and responsibilities. So they go on as an active participant at some point they experience a qualifying event and they lose coverage as a result of that qualifying event. So let's just assume that they lost employment, lost coverage, they experienced a qualifying event, the employee and any of their covered spouses or dependents lost coverage, so they should be provided an election notice. And according to the rules, that election notice needs to be provided at least 44 days after the qualifying event. The employer has 30 days to report the qualifying event to the TPA, and the TPA has an additional 14 days to send to the participant. But even though the rules say you have 44 days to provide the election notice, in reality it should be done as soon as possible and as close to the qualifying event as possible for practical administrative reasons. Once the employee or the COBRA beneficiary receives the election notice, they have up to 60 days to elect whether to continue coverage. So they can sit on that election notice for 60 days and consider their options, consider whether they're going to get covered by another employer, consider whether they're going to be covered by Medicare at some point. So they have 60 days to consider their options, which is quite a long time, considering that when they do in fact elect COBRA, if they do within those 60 days, they can elect coverage retroactive back to the qualifying event date. So they may have lost coverage up to 60 days prior, but they can elect coverage back to that qualifying event date. Once they do elect coverage, they have an additional 45 days to pay the initial premium. So now we're up to 105 days past the qualifying event and loss of coverage date, and the employee hasn't even paid for COBRA yet. So they can wait an additional 45 days after electing coverage to then go ahead and pay the initial premiums for retroactively for the couple of months since the qualifying event date. Once they elect coverage, and assuming they continued to pay premiums, the maximum COBRA coverage period is either 18 or 36 months, depending on the qualifying events. So that's the maximum coverage period during that time when they have coverage, and then once that period expires, then they lose coverage. They lose continuation coverage. So that's 18 or 36 months is the maximum coverage period. One thing we didn't get into on any of the slides is that it is possible for coverage to terminate early before the 18 or 36 months. For instance, if the COBRA beneficiary fails to pay their premium after 10 months of coverage, then the employer can terminate the employee. Or if the COBRA beneficiary goes and gets another job and enrolls in group coverage for their new employer, then the COBRA employer can terminate coverage for the COBRA beneficiary. So that's just a short outline of the timeline for COBRA, a very basic timeline. So as we talked about, one of the elements of COBRA is that a qualifying event occurs. We actually call them triggering events until a loss of coverage occurs, but triggering events and qualifying events can somewhat be used interchangeably, and so these are the 7 triggering events that can be qualifying events if there is a loss of coverage under the plan. The first 2 are termination of employment and reduction of hours of the covered employee. These 2 qualifying events can apply to both the employee and any covered spouse or dependents. So termination of employment or reduction of hours, those are the first 2. The next 4 triggering events would apply only to covered dependents or spouses. So ceasing to be a dependent child under the plan, so if a dependent ages off the plan or is no longer eligible for the plan, that dependent would be eligible for COBRA. Divorce or legal separation from a covered employee, so if a spouse and employee get divorced, the spouse loses coverage, the spouse is now eligible for COBRA. The covered employee becoming entitled to Medicare could potentially be a triggering event, although oftentimes when the employee becomes entitled to Medicare, no one loses coverage, so normally employees and covered dependents can continue to remain on the plan even when the employee becomes entitled to Medicare. So sometimes, even though entitlement to Medicare is a triggering event, it might not be a COBRA event because it doesn't cause a loss of coverage. And then finally, the death of a covered employee would also be a COBRA event for covered spouses and dependents. And then finally, in very rare circumstances for retiree-only plans, employee bankruptcy is a triggering event. But again, just to emphasize, in order for there to be a qualifying event under COBRA, there needs to first be a triggering event, and it also needs to cause a loss of coverage under the plan. Finally, with our basics, to sum up the last part of our discussion regarding the basics, I wanted to provide a list of the required notices and optional notices that are often recommended. I'm not going to go through the full list. The most important required notices are the initial notice and the election notice, and those required notices should be provided in a timely manner. And then finally, we do recommend many of the optional notices, even though they are optional and it could be a little more work to send them out, but often they aid in the administration of COBRA. Often they provide COBRA beneficiaries with some other options. Often it can trigger them to consider options under Medicare or options under the federal marketplace or options under another group plan. So oftentimes they're recommended just to aid in providing COBRA beneficiaries with more options and more understanding of their rights and responsibilities. And so with that, that's just a quick summary of the very, very basics of COBRA. I'm sure there are many questions because of how extensive COBRA is, but I just wanted to ask you, Jason, if you had any questions before moving on to our common questions.
Lots of good questions coming in, Chris, and I think I've answered most of them in writing, and we'll keep going through those, and we'll answer some at the end for those of you that would like to submit additional questions through the question box. We shared on a couple of quick ones. We shared on a prior slide, I'll go back to it, which employer-provided benefits may qualify as group health plans. One of the things listed on the screen and a popular benefit in 2017 is the telemedicine benefit. Chris, could you say a word about telemedicine and the two contexts it may be provided by an employer, either as part of the major medical plan provided by the carrier and whether COBRA would need to be offered separately, and then as a standalone benefit?
Sure, yeah. One of the problems with or difficulties with many of these benefits, EAPs, wellness programs, and especially telemedicine, one of the problems is how difficult COBRA administration actually is for these plans because oftentimes they're provided to all employees, not just those eligible for the medical plan. Oftentimes they're provided on sites for on-site clinics, and so it would be strange for terminated employees to now be coming back to the on-site clinic if they were offered COBRA. But in terms of how they're structured, sometimes the telemedicine could be part of the group health plan, essentially integrated as part of the group health plan, and that would generally be the easiest way for COBRA to have to be administered, because essentially if the COBRA beneficiary elected the medical plan, they would also have elected additional coverage under the telemedicine plan, and it probably makes things easier because the COBRA premium is probably already integrated into the medical plan, and eligibility is probably the same as the medical plan. So if the telemedicine plan is part of the medical plan, it makes things easier for COBRA administration. Now, sometimes telemedicine is offered separate. Often it's offered separate from the medical plan, which would make COBRA a little more challenging in terms of having to offer it to more employees than the medical plan. For instance, many telemedicine plans are offered to full and part-time employees. So that certainly is a challenge for some of these plans, and it does help if telemedicine is integrated in the group health plan.
Thanks, Chris. We got a number of questions regarding some of the notices. I'll go back to that slide. The first question, and first and most basic question, who is responsible to send these notices? The legal requirement, just to confirm, the legal requirement is on the employer. Now, the employer may use an outside entity. That's what we do at ProBenefits. We've got an entire COBRA team, and Chris serves as the compliance backup for the COBRA team, and our COBRA team sends notice. I mean, we've got a very high-tech system. In fact, when we send notices, whether they're required or optional, and everyone listed on the screen is one that we send in the appropriate scenarios, the notice goes out from a mailing house where there are 3 methods of proof. And, to date, knock on wood, with almost a decade of doing this, we've never had an issue being able to prove that a notice was sent via the mailbox rule, because we've got multiple methods of proof. But just to confirm, the legal requirements on the employer can outsource that requirement, and that's what we do, among other things, in addition to collecting the COBRA premium, remitting that to the employer, handling COBRA appeals, etc. But the notices must be provided. Another specific question, who is responsible to provide the initial notice upon hire and first eligibility in the health plan? The employer is required to provide that notice. As part of our administration, when we take over for an employer, we offer the employer the option that we could do a blanket initial notice to all employees just to make sure that requirement has been covered. Some employers do it, some do not, but certainly it's the best practice from that point forward, any new hire, or from this point forward, any new hires that you have, that they get the initial notice. Will the employee read it? No, and it won't even matter at that point, because they're not yet, COBRA eligible until there's a termination or other triggering event. But the initial notice is one of the required notices, and it's very important that employers comply with these requirements. We've got a number of good questions coming in. In the interest of time, let's proceed. Chris is going to now cover 4 common questions, and these will relate to some of the questions that have been submitted in the question box. 4 common questions that employers are asking about COBRA.
Yeah, and I didn't really structure them in terms of questions, but I think this first one is, regarding enrollment and plan changes for COBRA beneficiaries, often surprises employers. I think they're oftentimes surprised by the scope of changes and enrollment options that are available to COBRA beneficiaries. So open enrollment rights for COBRA beneficiaries are typically the same as active employees. When open enrollment comes around for the plan, it should also come around for COBRA beneficiaries as well. So during that time, COBRA beneficiaries could select new benefit options that they weren't enrolled in. For example, and that's just for group health plans. For example, the COBRA beneficiary may only be enrolled in the health plan, but the employer also offers a dental plan as well. And so when open enrollment comes around, the COBRA beneficiaries should have the opportunity to enroll in those additional group health plan benefit options, such as dental or vision plans. In addition, COBRA beneficiaries should be able to elect different plan options. So if there are 3 major medical plan options, during open enrollment, the COBRA beneficiary can enroll in one of the other plan options that they are not currently enrolled in. And that applies even if they weren't enrolled in those plans as active employees. They need to be given those options during open enrollment. And finally, COBRA beneficiaries can add or drop eligible dependents during open enrollment, just like active employees can as well. In order for COBRA beneficiaries to be aware of these options, they need to be provided with materials. They should generally be provided with all enrollment and plan document materials that active employees are provided, so they are aware of their coverage options. They are aware of if plan changes. This came up recently for a plan that significantly reduced their benefits, but didn't necessarily reduce the premium, and the COBRA beneficiary enrolled in the plan again, assuming that the plan was the same, and realized that a number of the providers weren't, or benefits that were offered previously were no longer being offered. And so when they enrolled, they weren't aware of this. And so it's important that COBRA beneficiaries have this information, because not only does it help them think about their COBRA options, but it may also sort of help push them towards some of their options as well. And updated SPDs and SBCs should also be provided to COBRA beneficiaries as well. And they should also generally be provided with the same opportunity to make mid-year qualifying event changes if they have a dependent, if they have a new child. They should be able to add those individuals during COBRA continuation. The next common question that comes up, there's often confusion regarding the disability extension. So as we talked about, for termination of employment and reduction in hours, the maximum coverage period is 18 months. However, if any beneficiary is determined to be disabled within the first 60 days of COBRA coverage and they notify the plan within a certain time frame, all beneficiaries, not just the disabled beneficiary, are eligible to up to 29 months of continuation coverage. And the purpose of that is to sort of bridge the gap from the loss of group coverage to Medicare for disability purposes. And so there's often a question as to what actually has to happen during those first 60 days, and what has to happen is the beneficiary must be disabled. Oftentimes the determination from the Social Security Administration does not come for several months after the disability. So we may be 10 months into COBRA and the beneficiary just now gets a determination of disability. But as long as that determination says the beneficiary was disabled during the first 60 days of COBRA coverage, then all the beneficiaries would be eligible for the extension of up to 29 months. And the beneficiary has to notify the plan. Sometimes they fail to do so, and generally that notification has to come within 60 days of receiving the disability determination, or within 60 days of the qualifying event, whichever happens later. So it's important that the beneficiary knows they are required to notify the employer of the disability determination. For those additional months, 19 through 29, the plan can charge up to 150% of the applicable premium. For months 1 through 18, it's generally 102% of the applicable premium, but 150% for the additional months as it relates to the disability extension. And then coverage can terminate prior to the 29 months, but after the 18 months if the beneficiary is determined to no longer be disabled during that time period. So that's just a quick explanation, tried to provide some clarity for the disability extension. We talked about this briefly. We have gotten questions, many common questions recently regarding state continuation. Who does it apply to? What exactly is required by state continuation? So states are permitted to add additional requirements beyond what is required by COBRA. States aren't required to add any additional requirements, but they can if they want to. And those additional requirements for the states that adopt state continuation often come in two forms. The first is sometimes those requirements provide employees not eligible for COBRA with the opportunity to continue coverage. So this is the case in North Carolina and applies to small employers. Under 20 employees. Those employers are not subject to COBRA. They don't need to offer full COBRA, but North Carolina says that these small employees still need to offer individuals losing coverage some continuation coverage, and that coverage is 18 months for employees at small employers who lose coverage. So that's one aspect of state continuation, is providing certain rights to individuals not subject to COBRA. The other aspect of state continuation is to provide additional continuation rights for COBRA beneficiaries. So I believe New York and California are two of the states that provide an additional 18 months on top of the maximum 18-month COBRA coverage period. So an employee in California, even if they're subject to a COBRA, they enroll in COBRA for the first 18 months, and then On top of that, the employer is often required to, or would be required to add an additional 18 months to the 18-month COBRA coverage period. So those are the two main aspects of state continuation for the states that do implement some additional requirements. Oftentimes, the state continuation requirements are less onerous. They generally only apply to fully insured medical plans, and the notifications are normally less onerous than COBRA, even though the concept of continuation coverage is very similar to COBRA. Finally, the last common scenario I want to talk about is when someone needs to correct a failure to offer COBRA, which if you're using a TPA, hopefully this isn't really happening, but sometimes employers that are not using an administrator and trying to do it on their own will sometimes miss a qualifying event and fail to offer COBRA coverage. And this is a big deal because it can cause a number of things: tax penalties or ERISA penalties, risk of litigation for medical claims and other statutory penalties, and some more consequences as well. So failing to offer COBRA when it should have been offered COBRA is a big deal. When possible, this failure should be corrected by doing two things: one, providing an election notice, and two, giving the beneficiary the opportunity to elect retroactive coverage. So if you think about this practically, though, there are some issues. If we're 3-4 months down the road and an election notice hasn't been provided, then the COBRA beneficiary is now going to be getting an election notice that says they can essentially have retroactive coverage back to the qualifying event. Well, there's a number of considerations. Is the insurance carrier going to provide that coverage back to the date of the qualifying event? It wasn't the insurance carrier's fault that the qualified beneficiary did not get the election notice. So the insurance carrier may refuse to provide retroactive or any coverage really for the COBRA beneficiary. So what does that mean? Would that mean the employer is now responsible for covering the beneficiary during the coverage period, and are they now liable for medical claims during those time periods? And so these are practical considerations that anyone in this scenario should be thinking about, and it's important to, if this scenario ever comes up, to talk to an expert, to proceed with caution, to consider what practical and legal ramifications and consequences exist in this scenario. But it's just important to think about things when, in the rare scenario that COBRA is failed to be offered to beneficiaries. So I think that's it in terms of the substance. Jason, if you want to jump back in.
Thanks, Chris. Those are 4 tedious topics, but very common issues that employers are running into regularly, and that we are seeing not only from our client base, the number of employers that we do COBRA for, but also other employers as well. I'm not going to, in the interest of time, we're going to wrap up here in a few moments. Your questions are still welcome through the question box. As a closing thought, I want to share a brief word about our COBRA administration. We're very proud of what we think is an absolute complete COBRA administrative service. We've got a dedicated COBRA team that includes Chris, and includes me, includes a number of folks at our administration team here at ProBenefits. We handle the notices, we handle premium collection and remittance to the employer. We take care of the details to make sure it's done right. One of the questions submitted through the question box: if an employer were doing COBRA itself, would it need to keep copies of all notices? Yes. How long? 7 years is the general ERISA standard, something we do for our employer clients, and this is true of not only COBRA but also FSA and HRA, is to maintain records electronically for at least 7 years so that our employer clients are protected in case they have to go back and retroactively prove something down the road. So we feel like we've got a great administrative service. We'd love to work with you. If that would be of assistance to you, feel free to contact us at any time. You can read when we send you the slides about the other items. In the interest of time, let us close with a thank you for joining us today, and an offer to submit your questions through the question box. You're also welcome to email Chris directly at Christopher@ProBenefits.com. But Chris and I will be monitoring the question box for the next 5 to 10 minutes. If you have submitted a question we haven't gotten to, or you would like to submit a question now, you're welcome to do that. Thanks to everyone for joining us. We had a huge crowd today. I think that speaks to the engagement of employers, number one, and also to the importance of this topic. And we will speak to you next month when we have our March the session, and an invitation for that to come, as well as a full webinar schedule available at ProBenefits.com. Thanks, and have a great day.